You are listening to HOA Meltdown Moments. The HOA tried to weaponize a property line. I am watching you. That was the first thing Kimberly Jackson said when she walked up my driveway holding a clipboard like a court summons. She was pointing at the half-built fence behind me, the one I had approval for, the one that was supposed to be done by Tuesday so I could finally stop worrying about the neighbor's dog getting into my yard. Karen yelled that the board could force a teardown, and she said it like she was excited. Her smile was huge. She tapped the clipboard with a highlighter and said the fence violated setback by 3 inches, and I had 48 hours to remove it, or the HOA would do it for me and charge me for labor. I work as a regional field technician, always on a deadline, always driving between sites. I had taken a half day off just to meet the contractor and make sure the posts went in clean. Now this woman was standing in my driveway in a blue cardigan and pink bucket hat, waving a clipboard full of colored tabs, telling me my fence was illegal. I live in Buffalo, New York, in a neighborhood called Lakeshore Landing, and everything here requires a form, and the form requires another form. This is a community where leadership treats neighbors like suspects during renovations. The HOA is officially called the Lakeshore Landing Fence Compliance Association, which should have been my first clue. Kimberly is the rules interpretation chair. She claims she wrote the covenants herself, which is not true, but she says it anyway. I moved here 6 months ago because I needed something affordable while I saved up for a real down payment on a house outside the association zone. I had plans. I had a timeline. And now this woman was about to drain me with bogus fees over 3 inches. She smiled wider. Keep arguing. You are making my case for me. I held up my approval packet, the one the HOA management company had stamped and returned. Kimberly did not even look at it. She said the board reinterpreted the setback rule last month, and I should have known. I asked when that update was published. She said it was discussed in a meeting I did not attend. I said I was never notified of the meeting. She said that was my problem. The contractor was standing next to his truck, watching this whole thing. He was a guy named Miguel, mid-50s, who had done fence work in Lakeshore Landing before. He looked uncomfortable. Kimberly turned to him and said if he continued the install, the association would add him to a non-approved vendor list and he would never work another job in the neighborhood. Miguel looked at me. I told him to keep going. Kimberly wrote something on her clipboard and said she was calling management and she was going to be dramatic about it. She walked back to her car, a white sedan parked at the curb, and made a big show of pulling out her phone. I could see her talking and gesturing. Miguel said he needed to make a call too. He stepped away. I stood there holding my approval packet, my bundle of fence pickets leaning against my leg, trying to figure out what just happened. I called the management company. I got a voicemail. I called again. Another voicemail. I sent an email with photos of my approval and the current fence line. No response. Miguel came back and said he was sorry, but he could not finish today. He said Kimberly had connections and he could not risk being blacklisted. He would come back once I sorted it out with the board. He loaded his tools and left. I was standing in my driveway with half a fence, a pile of pickets, and no idea what to do next. That was Friday afternoon. Saturday morning, I got a certified letter. It was a formal violation notice. The fence exceeded setback tolerance, failed material compliance review, and violated aesthetic continuity standards. I had 72 hours to remove it, or the association would contract removal and bill me. The fine schedule started at $500 and increased $50 per day. I read it twice. None of it made sense. My approval specifically listed the fence style, the height, the setback measurement. I had followed every rule. I pulled out the original covenant documents and read the setback section. It said fences must be set back at least 12 inches from the property line. My fence was 15 inches back. I had measured it myself with a tape measure before Miguel started digging. I called the surveyor who had marked my property line when I bought the house. He said he could come back out and confirm the line, but it would take a week because he was booked. I said I did not have a week. He said he would try to move things around. I went outside to take more photos. Kimberly was parked across the street, sitting in her white sedan, watching my house. When she saw me looking, she smiled and waved. Then she got out of the car, walked over, and said the clock was ticking. She said the board meeting was Monday night and they were going to vote on an emergency removal order. She said I could appeal, but the appeal process took 30 days and the fines would keep adding up. I asked if I could attend the meeting. She said it was closed session. I said that was not legal. She said she would let me know what they decided. I started recording. I pulled out my phone and opened the voice memo app. Every time Kimberly came by, I recorded. Every conversation, every threat, every claim. My phone storage was almost full and I had to back up video evidence before it got lost. So I spent Saturday night uploading everything to cloud storage and labeling files by date and time. Sunday morning, Kimberly showed up again. This time, she had someone with her, a man in a reflective vest who she introduced as the association's compliance inspector. He walked the fence line with a tape measure and a clipboard. He did not say much. Kimberly did all the talking. She said the posts were crooked, the boards were uneven, the color was not pre-approved. I said I had submitted a color sample. She said the sample I submitted was not the color on the fence. I said it was the exact same stain. She said I was wrong. The compliance inspector measured the setback, 15 inches. He wrote it down. Kimberly looked over his shoulder and said the measurement was from the wrong reference point. She said the property line shifted during grading and the fence was actually only 9 inches back. I said that made no sense. She said she was calling a second surveyor to confirm. I stayed polite because polite makes bullies careless. I did not yell. I did not argue. I just kept recording and taking notes. Monday morning, I got an email from the management company. It said the board had reviewed my case and determined that my fence violated multiple covenant sections. The removal order was approved. I had until Wednesday at noon to dismantle the fence or the association would hire a contractor to remove it and bill me for the work plus administrative fees. Total estimated cost, $3,000. I called a lawyer. The consultation was free. She listened to the whole story and said HOA disputes were messy and expensive. She said I could fight it, but it would take months, and I would probably spend more on legal fees than the fence was worth. She said the association was banking on me giving up. She asked if I had documentation. I said I had everything. She said that was good. She told me to keep recording and to file a formal appeal in writing even if I knew it would be denied. She said the paper trail mattered. I filed the appeal that afternoon. I included photos, measurements, my original approval, the surveyor report, and a timeline of every interaction with Kimberly. I sent it certified mail to the management company and copied the board. Tuesday morning, Kimberly was back. She had a truck with her this time, a flatbed with a magnetic placard on the door. The placard had the HOA logo and the words authorized vendor. 2 men got out and started walking toward my fence. I stepped outside and asked what they were doing. Kimberly said the board authorized preemptive removal to avoid further non-compliance. I said the deadline was Wednesday at noon. She said the board moved it up. I told the workers to stop. I said I had not authorized removal and the fence was my property. One of them looked at Kimberly. She said the association owned the covenant enforcement rights and could remove non-compliant structures. I said that was not true. She said I could sue if I disagreed. I called the police, the non-emergency line. I explained the situation. The dispatcher said it sounded like a civil matter and they could not intervene unless there was a crime in progress. I asked if trespassing counted. She said if I told them to leave and they refused, that was trespassing. I told the workers to leave my property. They looked at Kimberly again. She said they were operating under HOA authority. I repeated that they needed to leave. One of them shrugged and said this was not worth it. They got back in the truck and left. Kimberly did not leave. She stood in my driveway and said I just made everything worse. She said the board would add obstruction fees. She said I was going to regret this. I kept my phone out, recording. She saw it and smiled. She said recording me without consent was illegal in New York. I said New York was a one-party consent state and I was a party to the conversation. Her smile faded a little. She left. I called the surveyor again. He said he could come out that afternoon. I said yes. He showed up at 4. He spent an hour running a transit line and checking his old markers. When he was done, he said the property line had not moved. He said my fence was 15 inches back, exactly where it should be. He said he would write a report and email it to me by end of day. I asked if he could send a copy to the HOA management company. He said sure. Wednesday morning, I got a call from a number I did not recognize. It was a woman from the HOA management company. She said the board was reviewing my appeal and they needed more time. She said the removal order was on hold pending review. I asked how long that would take. She said 2 weeks. I said that was fine. She said the fines were still accruing. I said the fines were invalid because the fence was compliant. She said the board would make that determination. I asked if I could get a copy of the meeting minutes from Monday night. She said those were not public. I said HOA meeting minutes were required to be available to members under New York law. She said she would check with the board. Thursday, I got an email with a PDF attachment. It was the meeting minutes. They were 3 sentences long. The board reviewed a fence violation at my address. The board voted to uphold the violation. The board authorized removal. No discussion summary, no vote count, no details. I forwarded it to the lawyer. She said it was garbage and would not hold up if I challenged it. She said the board was required to document their reasoning and provide me an opportunity to respond. She said I should request a formal hearing. I said I already appealed. She said appeal and hearing were different. She sent me a template letter. I sent the hearing request Friday morning. Friday afternoon, Kimberly showed up again. This time she had a different clipboard. She said she was conducting a property inspection. I asked under what authority. She said the covenants allowed the board to inspect exterior compliance. I said the covenants required 72 hours notice for inspections. She said emergency inspections were exempt. I asked what the emergency was. She said ongoing non-compliance. She walked around my yard with a measuring tape, taking notes. She measured the fence, the driveway, the gap between my house and the property line. She took photos. She did not ask permission. I followed her with my phone, recording everything. She stopped at the mailbox cluster near the curb. A few neighbors were getting their mail. Kimberly started talking to them. She said I was refusing to follow the rules. She said the fence was illegal. She said if the board did not enforce compliance, property values would drop. One of the neighbors, an older guy named Ray, asked what was wrong with the fence. Kimberly said it was too close to the line. Ray looked at the fence and said it looked fine to him. Kimberly said he was not on the board and his opinion did not matter. Ray frowned. He said he used to be on the board and the setback rule was 12 inches. Kimberly said the rule changed. Ray said when. Kimberly said last month. Ray said he did not get a notice about that. Kimberly said the notice was posted on the association website. Ray pulled out his phone and said the website had not been updated since March. Kimberly said he was mistaken. Another neighbor, a woman named Diane, asked if the HOA was really going to tear down someone's fence over 3 inches. Kimberly said it was about maintaining standards. Diane said it sounded like harassment. Kimberly said if people did not like the rules, they could move. Ray told me later that Kimberly had been pulling stunts like this for 2 years. He said she got on the board after a vote where only 4 people showed up. He said she had a list of homes she targeted, mostly people who were new or who had filed complaints about other issues. He said I should check the meeting attendance records because Kimberly had been holding votes when no one else could attend. I started digging. I requested copies of the last 12 months of meeting notices and minutes. The management company sent me a zip file. I opened it and started reading. Out of 12 meetings, 8 had fewer than 5 attendees. 3 had only Kimberly and 1 other board member. The meeting where they reinterpreted the setback rule had 3 people present, including Kimberly. I also found something else. In the file was a spreadsheet labeled Compliance Tracking. It had a list of addresses and violation categories. My address was highlighted in yellow with a note that said Priority Enforcement. There were 6 other addresses highlighted the same way. I recognized 2 of them. One was Ray. One was a guy who had complained about Kimberly blocking street parking during a party. I forwarded the spreadsheet to the lawyer. She said it looked like targeted harassment and I should document everything. She said if I could prove Kimberly was selectively enforcing rules, I could file a complaint with the state attorney general. She said HOAs were required to enforce rules evenly. Saturday morning, I got a notice taped to my front door. It said the hearing was scheduled for Monday at 7 in the evening at the community center. It said I had 15 minutes to present my case. It said the board's decision was final and binding. I spent the weekend preparing. I printed the surveyor report, the original approval, the meeting attendance records, the spreadsheet, and a timeline of every interaction with Kimberly. I labeled everything. I put it in a binder with tabs. I also made a second copy and mailed it to the management company with a cover letter saying I was providing evidence in advance of the hearing. Sunday night, Kimberly showed up at my house at 9:30. I was in bed. I heard a noise outside and looked out the window. She was in my backyard with a flashlight, walking the fence line. I went outside and asked what she was doing. She said she was conducting a follow-up inspection. I said it was 9:30 at night. She said the covenants did not specify inspection hours. I told her she was trespassing and needed to leave. She said she was acting in her official capacity. I said I was calling the police. She left before I finished dialing. I called anyway and filed a report. The officer who came out took my statement and said I could request a trespass warning. I said yes. He said he would follow up with Kimberly and let her know she was not allowed on my property without permission. He also said I should consider a restraining order if it continued. I said I would. Monday night, I showed up at the community center at 6:45. The hearing room was a small conference room with a folding table and chairs. Kimberly was already there, sitting at the head of the table with her clipboard. There were 2 other board members, a man named Frank and a woman named Lori. They both looked uncomfortable. I sat down and put my binder on the table. Kimberly said the hearing would start at 7. No one else came in. At 7, she called the meeting to order. She said I had 15 minutes to present my case. I said I wanted the hearing recorded. She said that was not allowed. I said New York law allowed me to record proceedings where I was a party. She said this was a private HOA matter. I said I was recording anyway and placed my phone on the table with the voice memo app running. Frank looked at Lori. Lori looked at Kimberly. Kimberly said if I did not turn off the phone, the hearing would be terminated and the violation would stand. I said that was fine. I would file a complaint with the state. Frank said maybe they should just let him record. Kimberly glared at him but did not say anything else. I started. I walked through the timeline. I showed the original approval. I showed the surveyor report. I showed the measurements. I showed the covenant language. I explained that my fence was compliant in every way. I showed the meeting attendance records and the spreadsheet with my address highlighted. I said the enforcement was selective and retaliatory. Kimberly interrupted 3 times. She said the surveyor was wrong. She said the approval was outdated. She said the spreadsheet was taken out of context. I asked her to explain the context. She said it was none of my business. Frank asked if the setback rule really changed. Kimberly said yes. Frank asked when. Kimberly said last month. Frank said he did not remember voting on that. Kimberly said it was an administrative clarification, not a vote. Frank said that did not sound right. Lori asked if I had any other issues with the HOA. I said no, this was the first time I had dealt with them. Lori asked Kimberly why my address was highlighted on the spreadsheet. Kimberly said it was a tracking tool. Lori asked why only some addresses were highlighted. Kimberly said it was based on risk assessment. Lori said that sounded like profiling. Kimberly stood up. She said the hearing was over. She said the board would deliberate and notify me of their decision. I said I was not done presenting. Kimberly said my 15 minutes were up. I checked my phone. It had been 12 minutes. I said that. Frank said maybe they should let him finish. Kimberly said the hearing rules were at her discretion as chair. Frank said he did not think that was fair. Kimberly said if Frank and Lori did not want to support enforcement, they could resign from the board. Frank said that was not what he said. Kimberly picked up her clipboard and walked out. Frank and Lori stayed. Frank said he was sorry. He said Kimberly had been difficult to work with for a while. He said he did not know about the spreadsheet. He asked if he could see it. I showed him. He took a photo with his phone. He said he was going to talk to the management company. Lori said the fence looked fine to her. She said if the surveyor confirmed the setback, she did not see a problem. She said she would vote to dismiss the violation. Frank said he would too. I asked if that was enough. Frank said the board had 5 members and they needed 3 votes. I asked where the other 2 were. Frank said one resigned last month and the other one never came to meetings. I asked who was the other one. Frank said it was a guy named Todd who was Kimberly's friend. I asked what happened if the vote was tied. Frank said Kimberly would claim chair authority and force it through. I asked if that was legal. Frank said probably not, but no one had challenged it. I went home. I did not sleep much. I kept checking my email. Nothing. Tuesday morning, I got a call from the management company. It was the same woman from before. She said the board vote was 2-1 in favor of dismissing the violation. She said Kimberly had objected and demanded a recount. She said the management company reviewed the process and determined the vote was valid. She said the violation was dismissed and the fines were canceled. She said I did not owe anything. I asked about the removal threat. She said that was void. I asked about Kimberly's trespass. She said that was a separate issue and I should handle it with the police. I asked if the board was going to do anything about Kimberly's conduct. She said the board would discuss it at the next meeting. I called the surveyor and asked him to email his report directly to the city zoning office. I wanted it on record. He said sure. I also called the city clerk and asked if the HOA had filed any variance requests or zoning complaints related to my address. The clerk checked and said no. I asked if the HOA had claimed my fence violated a city ordinance. She checked again. She said the HOA had sent a letter in April claiming my property was in violation of setback requirements under city code. I said that was before I even built the fence. She said the letter referenced a future fence installation. I asked for a copy of the letter. She said she would email it. The letter was insane. It said I was planning to build a fence that would violate city setback by 6 inches. It said the HOA requested the city deny any permits. It was signed by Kimberly. The problem was, I had never applied for a city permit because the city did not require permits for fences under 6 feet on private residential property. The whole letter was based on a fake permit application. I forwarded it to the lawyer. She said that was fraud. She said Kimberly had misrepresented facts to a government agency in writing. She said I should file a complaint with the city and also report it to the HOA management company and the board. I did both. I filed a formal complaint with the city clerk's office. I attached the letter, the surveyor report, and a timeline. The clerk said they would investigate. I also sent everything to the management company with a cover letter requesting an emergency board meeting to address Kimberly's conduct. Wednesday morning, Kimberly called me. I did not answer. She left a voicemail. She said I was making a big mistake. She said the board would not tolerate retaliation. She said I was harassing her. I saved the voicemail and forwarded it to the lawyer. Thursday, I got an email from the management company. They said the board had scheduled a special meeting for Friday night to discuss my complaint. They said Kimberly would not be chairing the meeting. Frank would. They said I was invited to attend. Friday night, I showed up at the community center again. This time there were more people. Ray was there. Diane was there. A few other neighbors I recognized. Frank was at the head of the table. Lori was next to him. Kimberly was sitting in the corner with her arms crossed. Todd, the 5th board member, was not there. Frank called the meeting to order. He said they were there to discuss concerns about selective enforcement and board member conduct. He said he had reviewed the evidence I submitted, and he had concerns. He said the board needed to address it. Kimberly interrupted. She said this was a witch hunt. She said I was a troublemaker who refused to follow the rules. She said the board was setting a dangerous precedent by caving to pressure. Frank said the board was following the covenants and the law. Kimberly said the covenants gave the board discretion. Frank said discretion was not the same as discrimination. Ray stood up. He said he wanted to speak. Frank said go ahead. Ray said Kimberly had targeted him 2 years ago over a mailbox placement. He said she had fined him $800 for a mailbox that was 2 inches off center. He said when he asked for a hearing, she scheduled it during his work hours and refused to reschedule. He said he ended up paying the fine because he could not afford a lawyer. He said he had photos and emails if anyone wanted to see them. Diane stood up. She said Kimberly had threatened to tow her car 3 times in 1 month for parking in a guest spot. She said the guest spots were supposed to be first come, first serve, but Kimberly claimed Diane was abusing the policy. She said Kimberly never defined what abuse meant. She said she stopped having guests over because she was afraid of getting fined. Another neighbor, a younger guy named Marcus, said Kimberly had sent him a violation notice for leaving his trash cans out past 7 in the morning. He said the notice claimed pickup was at 6. He said he called the trash company and they confirmed pickup was at 8. He said when he showed Kimberly the email from the trash company, she said the covenant rules superseded the pickup schedule. Frank looked at Kimberly. He said he was hearing a pattern. He asked if she wanted to respond. Kimberly said everyone in the room was lying. She said they were coordinating to get rid of her because she was the only one willing to enforce the rules. She said if the board removed her, the neighborhood would fall apart. Lori said she had a question. She asked Kimberly about the spreadsheet with the highlighted addresses. She asked why those specific homes were flagged. Kimberly said it was an enforcement priority list. Lori asked who decided the priorities. Kimberly said she did. Lori asked based on what criteria. Kimberly said based on risk. Lori asked what that meant. Kimberly said it was complicated. Lori said it did not sound complicated. She said it sounded like Kimberly was targeting people who disagreed with her. Kimberly said that was ridiculous. Lori said then explain Ray and Marcus. Kimberly said they both had multiple violations. Lori asked for documentation. Kimberly said it was in the files. Lori said she had reviewed the files and there was no documentation. Kimberly said Lori did not have access to all the files. Lori said she was on the board and she absolutely had access. Kimberly did not respond. Frank said the board needed to vote on whether to remove Kimberly as chair. Kimberly said they did not have the authority. Frank said the bylaws allowed the board to remove an officer with a majority vote. Kimberly said the bylaws required a special meeting with 10 days' notice. Frank said this was a special meeting. Kimberly said the notice did not specify a removal vote. Frank said the notice specified board member conduct, which included removal. Kimberly stood up. She said if they voted, she would sue. Frank said that was her right. He called for a vote. Lori voted yes. Frank voted yes. Todd was not there. The vote was 2-0. Kimberly said it was invalid without a quorum. Frank said 3 board members constituted a quorum under the bylaws. Kimberly said Todd had to be present. Frank said Todd had been notified and chose not to attend. If you are enjoying this HOA nightmare, hit that like button and subscribe for more unbelievable stories. Frank said the vote stood. Kimberly was removed as chair. Frank was now acting chair. He said the board would schedule elections for next month. Kimberly said she was still on the board. Frank said that was correct, but she no longer had chair authority. Kimberly said she could still call for votes. Frank said only the chair could call votes. Kimberly said she would challenge this at the next meeting. Frank said the next meeting was in 2 weeks and she was welcome to attend. Kimberly grabbed her clipboard and left. She slammed the door on the way out. Frank looked at me. He said he was sorry it took this long. He said the board would issue a formal dismissal of all violations related to my fence. He said the management company would send a letter. He asked if I wanted to pursue any further action. I said I wanted the trespass warning enforced. He said that was a police matter, but he would include a note in the meeting minutes supporting my request. Ray came up to me after the meeting. He said I should run for the board. I said I was not interested in HOA politics. He said that was exactly why I should run. He said people who wanted power were the wrong people to have it. I said I would think about it. I went home and checked my doorbell camera. Kimberly had been by my house 3 times that week. Twice at night. Once at 6 in the morning. Every time she walked the fence line with her phone out, taking photos and videos. I downloaded all the footage and saved it. I also filed a second police report with the new footage attached. Saturday morning, I got a call from a number I did not recognize. It was a guy named Steve. He said he was the owner of the tow company that Kimberly had tried to use to threaten my contractor. He said he was calling because he had seen my name in a group chat and wanted to give me a heads up. He said Kimberly had a list of vendors she worked with and she paid them under the table to do enforcement work the board did not approve. He said she had been doing it for at least a year. He said he cut ties with her after he found out she was misrepresenting HOA authority. I asked if he would be willing to document that. He said yes. He said he had emails and text messages. He said he would forward them to me. I gave him my email address. The emails came through Sunday afternoon. They were exactly what Steve said. Kimberly had been offering cash payments to tow companies, contractors, and landscapers to target specific homes. The emails included my address, Ray's address, and 4 others. One email said priority removal, and another said do not notify owner. There was also a thread where Kimberly asked a contractor to inflate a quote for fence removal so the homeowner would be more likely to give up. I forwarded everything to the lawyer, the management company, Frank, and the city clerk. The lawyer said this was wire fraud and conspiracy. She said I should file a police report. I did. Monday morning, 2 detectives showed up at my house. They said they were investigating a complaint related to HOA fraud. I showed them everything. They took copies. They said they would follow up with the management company and the board. They also said they would talk to Kimberly. Tuesday, I got a call from the management company. The woman said Kimberly had been removed from the board effective immediately. She said the board voted unanimously to terminate her membership. She said the management company was also terminating their contract with her as a consultant. I asked if she had been a paid consultant. The woman said yes, Kimberly had been paid $200 a month to review compliance cases. I asked if that was a conflict of interest. The woman said the management company was reviewing their policies. Wednesday, I got a letter from the police. It said a formal trespass warning had been issued to Kimberly Jackson. It said if she entered my property again without permission, she would be arrested. It included an incident number and the name of the officer who filed the report. Thursday, the city clerk emailed me. She said the investigation into Kimberly's letter was complete. She said the letter contained false statements and the city was issuing a formal correction. She said the city would also be notifying the HOA management company that any future complaints from the association would require verification. She said I could request a copy of the city's findings for my records. I said yes. Friday, I got the correction letter from the city. It said the HOA's claim that my fence violated city code was unfounded. It said the city had no record of a permit application or any zoning violation. It said the city confirmed that residential fences under 6 feet did not require permits in my zoning district. It said the HOA's letter appeared to be based on incorrect information. The letter was signed by the city zoning administrator. I printed 3 copies, one for me, one for my records, one to frame. Saturday, I went to a hardware store to buy stain for the fence. I ran into Miguel, my original contractor. He said he heard what happened. He said Steve had told him. He asked if I still needed the fence finished. I said yes. He said he would come by Monday. Monday morning, Miguel showed up with his crew. They finished the fence in 4 hours. It looked perfect. Straight, level, stained exactly 15 inches from the property line. Miguel said no charge for the labor. He said I had done him a favor by exposing Kimberly's vendor shakedown. He said half the contractors in the area had been dealing with her threats for 2 years. I tried to pay him anyway. He said buy him lunch sometime. That afternoon, Frank called me. He said the board was scheduling a special election to fill the vacant seats. He said they wanted to make sure people like Kimberly did not get back on. He said I should run. I said maybe. He said think about it. I thought about it. I decided not to run, but I did show up to vote. Ray ran. Diane ran. A few other neighbors ran. All of them won. The new board passed a resolution requiring all enforcement actions to be approved by a majority vote. They also passed a rule requiring the management company to publish meeting minutes within 7 days. They fired the compliance inspector Kimberly had hired. 2 weeks later, I got a check in the mail from the HOA. It was a refund for the bogus fines. $300. The memo line said compliance review adjustment. I deposited it. 3 weeks after that, I got a letter from Kimberly's lawyer. It said she was suing me for defamation, harassment, and conspiracy. It said I had damaged her reputation and caused her emotional distress. It said she was seeking $50,000 in damages. The letter included a list of allegations, most of them completely false. I forwarded it to my lawyer. My lawyer laughed. She said the lawsuit was frivolous. She said Kimberly was trying to intimidate me into dropping the police complaint. She said we would file a motion to dismiss and countersue for legal fees. She said not to worry. The motion to dismiss was granted. The judge said Kimberly's claims were baseless and unsupported by evidence. The judge also awarded me attorney's fees. Kimberly appealed. The appeal was denied. 4 months later, the district attorney filed charges. Kimberly was charged with wire fraud, filing a false government report, and attempted extortion. The charges were based on the emails Steve provided, the fake city letter, and recorded conversations with 3 other homeowners who came forward after my case went public. The trial took 6 months. Kimberly was convicted on 2 of the 3 charges. She was sentenced to probation and ordered to pay restitution to the HOA and the affected homeowners. The HOA held a special meeting to vote on whether to pursue a civil case against Kimberly for the money she had taken as a consultant while simultaneously targeting homeowners. The board voted yes. They filed a lawsuit. Kimberly settled before it went to trial. The settlement was sealed, but Ray told me later it was enough to cover the legal fees and refund every bogus fine she had issued in 2 years. The new board also voted to drop all pending violation cases and start fresh with a transparent review process. They hired a new management company. They published the covenants online with a plain language guide. They set up a dispute resolution process that required mediation before fines. They banned nighttime inspections. I still live in Lakeshore Landing. The fence is still standing. I get compliments on it from neighbors. Ray is now the board president. Diane is vice president. The HOA is boring now, which is exactly how it should be. I appreciate your support.